Hi, everyone. Carmen Disco here with the UIA TV educational series. We are on show number 28, and we are moving along, going through so much stuff, so many knowledgeable guests and speakers that we've had on. And we, I think, are on show number 28, which is awesome. Got a lot of cool stuff happening. Let me bring on my co-host, man of the hour, Mr. Warren Tuttle. Hey, Warren, what's going on, my friend?
Hey, Carmine, good to see you. You know, you and I together have done over 50 of these. So,
it's amazing. I mean, I think I had hair when we first started this.
Don't go there. But no, it's been great. And now we're moving into the spring, and we've got a couple more weeks, and then we're going to take a break, and then we're going to start up a new 10-part series. So
yeah, I tell you, it's never ending. But the great part is that we get a lot of feedback, a lot of information, a lot of questions in. So, we're helping some people out there. I'd say, it took some time to catch up, and now it's moving along. I love it.
Well, it's great. And today's show I'm really excited about, but one of the things is we cover a lot of different topics. For those who are watching for the first time, we just recently had on Aaron Krause of Scrub Daddy fame. We've had all types of different shows. Today's going to be a little different show for everyone, and it's about really inventor advocacy. And why don't I jump right in, Carmen, if you don't mind?
Go ahead. I've been waiting for this show. It's awesome.
But we have three amazing guests today. We have Judge Susan Braden, who we'll get to in a moment. We have Rob Greenspoon and Josh Malone. I'm going to let each one of them take a few minutes to introduce themselves, but let me just add that Judge is also a board member of the UIA and is also a PPAC, a Patent Advisory Council for the United States Patent and Trademark Office. Rob is an unbelievable patent attorney of national fame, based out of Chicago. I've known him many, many years. And Josh, besides being one of the most successful inventors in the United States with a bunch of balloons, has really dedicated a lot of time to inventor advocacy with U.S. Inventor in Washington, D.C. So today's subject is small claims patent court, and we're going to get there in a moment with Rob next, describing a little bit of that, and then Judge jumping in. But I'd like to start with Josh. Maybe just Josh, say hello to everybody. Maybe introduce yourself real quickly, and then maybe we'll start there with the plight of the inventors right now, and maybe you can give us a backdrop on that.
Yeah, thanks. It's good to be here. Really looking forward to this conversation. I'm an inventor. Quit my job. Now it's been many years ago to take the plunge and pursue the American dream. And had several inventions, and a couple of them made it to the market, and one of them made it in a big way. And so I got to see what happens next. And I got to spend many years sorting out the rights to my invention and trying to fend off pirates, and got involved with U.S. Inventor and UIA, and just really being able to recognizing that inventors really do need a voice when it comes to patent policy, whether it's in Congress or the patent office or in the courts. And so that's what I hope that I'm accomplishing. Looking forward to talking more about what we're doing with you today.
So that's awesome. And, maybe just quickly, a minute or two, what are the biggest challenges right now? Is it I know you could go on for hours about this, but just if you could summarize, what are some of the things that you are most concerned about for inventors these days?
Well, the system has evolved with respect to huge multi-billion-dollar and now trillion-dollar corporations. And so when you have a dispute over a patent, it goes nuclear. And these issues now take a decade or more. I've met inventors who've been in court for 15 years. It costs not hundreds of thousands of dollars, not millions of dollars. It costs tens of millions of dollars in legal fees to sort through these disputes. And some of them are legitimate disputes, but the way the rules have evolved and the procedures and the tactics and the strategies, you can make a mountain out of a molehill. And just to illustrate briefly what I'm talking about, my invention, bunch of balloons, I won't rehash that. My story's out there for those of you that are interested. There's two issues when it comes to patent disputes: infringement and validity of the patent. And so in my case, here's the summary. I had the cleanest case on both of those issues in decades. So in terms of infringement, these guys copied it, flat out copied it, changed the color and changed the name. And so we had them dead to rights on infringement. They were guilty. On validity, I had a technology that had been, there had been no improvement in 63 years. People were filling water balloons one at a time and tying them with a knot. And since my invention, it's almost universally the only way to fill water balloons. So it wasn't obvious. And so despite that being a very extremely clear-cut case, it should have been open and shut. We ended up in this massive, high risk, high stakes, super expensive litigation that I nearly lost. Every week there was one more potential pitfall that would have wiped us out. We're in courts all across the country. We're in appeals courts, second highest court in the land. I was there 14 times. They can appeal everything, the motions, the filings. I mean, enough paper to fill a room. 29 different attorneys from 6 different firms, and that was just my side. And so, no one could get through this, and just an uncountable number of miracles and things that went my way. I was able to just slog away and get through this process and survive these endless attacks in the courts. And at the end of it, we ended up with spending $20 million on legal fees, and ours was stopped early. And so I'm going to kick it back to you, Warren, in just a moment. The bottom line is we had deeper pockets and more staying power than the guys who stole my invention. It had very little to do with the merits, the quality of the patent, the fact that I followed the rules, that I had an invention and it was properly examined, properly issued. That really didn't matter. What mattered was we outlasted these guys, and that's no way to run a justice system. That's no way to promote innovation, and it shuts out the vast majority of innovators and small businesses. So I'm very excited to talk about that solution because we need it.
Thank you, Josh, and thanks for all your efforts on behalf of inventors. And it's great that you were so hands-on because you have lived the experience. I mean, a lot of people write about it, they talk about it, but you've been right there at ground zero living it. And it's spent so much time, advocating and everything that you've done, which again, people can read about. But what I'd like to do is shift over to Rob. And I've known Rob a long time, and Rob has also served on the UIA board and also been a helper of inventors. And he wrote a paper a few years back about a potential solution in this area, small claims patent court. And so Rob, maybe you just take us a little bit through how you got there and what's going on today.
Yeah, absolutely. Thank you, Warren. And, thank you and Josh, of course, and Carmine for all you do for inventors. It's terrific. It's fabulous. I'm really privileged to be here today to talk about this issue because it is one that I've thought about and worked hard for over a decade. Just to segue a bit from Josh, I had the privilege of being one of his 29 lawyers. And just to sort of give the flavor for what Josh had to go through, which I shared with him a little bit. I argued one of his cases in front of the Patent Trial and Appeal Board, the PTAB, after he had already won the jury trial. And one of the arguments we were making to this panel of judges was the opponent had already litigated these issues and lost. So why are we even still talking about this? And it's an issue called collateral estoppel or issue preclusion. So I remember distinctly making my arguments about issue preclusion to these 3 well-intentioned bureaucrats. They're well-intentioned, but they're still bureaucrats. And just being astonished at the blank stares. It just was not resonating with my audience that this case was already over. I mean, that's just one of the challenges and struggles of inventors, that you have these parallel litigations that can happen on the same issues and nothing is ever over. But on small claims in particular, so I'm a patent attorney, a litigator, a trial attorney. I operate at every level of the patent office, of the court system, up to the Supreme Court. And midway into my career, I'd been doing this kind of work for about a dozen years. it occurred to me that I was getting really bothered by the access to justice problem and the fact that most infringement is small scale infringement, but there are no real practical ways, or there were not at the time and still aren't, for getting relief from what we might call small scale infringement. And at the time, our thought process was $1 million or less in a claim for damages would be considered small scale, even though that's a huge amount of money for any regular person. So it was 2009 when I published the article. Apparently it made some noise. It led to some action inside the patent office where we had some meetings. There were requests for comments. And I'm going to share with you a little bit about what UIA did at the time. Now we're in 2013, and we submitted our own response to the request for comments on the topic of a small claims court. How can we bring access to justice to this population of folks who don't have it? And in what we wrote, UIA, and Warren, you co-signed this, by the way, this letter we wrote, and I did too. Quote, not a single survey respondent, because we had taken a survey of inventors at the time, not a single respondent of individual inventors believes that the current system of challenging infringement is effective for most individual inventors. In addition, 95% of all respondents believe that the cost of defending a patent, in other words, enforcing against an infringer, is unaffordable to most inventors. And only 10% of the survey respondents disagreed that with the proposition that the ability to enforce affects the decision to pursue patent protection in the first place. So this is a question of inventor morale as much as access to justice. And when you deprive people of hope, you deprive people of the entryway into a paradigm or program or a system that ought to be there to change their lives and improve the lives of people around the world. So that's what led to me writing the article and working hard on this issue. And then why we're here now, perhaps, is because we got a breath of fresh life into the question of a patent small claims court. And we got that breath of life from the fact that last year, Congress and the president enacted a new law in the world of copyrights, and that's called the CASE Act. I have what CASE stands for, copyright something, I'm sure. But the CASE Act is a small claims court process that they've established just for copyright, not for patent, very different. And it's going to have some really significant limitations when it goes into effect. Now it's scheduled to go into effect December 27th of this year. That could be delayed up to 6 months if the agency feels they're not ready yet. And this would be a tribunal inside the Copyright Office. The main driver for putting this into action was an organization, a trade association, not very different in structure from the UIA or US Inventor, where called the NPPA, the National Press Photographers Association. So they were the drivers behind this legislation. And the main features of this litigation are going to be that the limit for the claim is going to be, get ready for it, $30,000.
Oh, ouch.
So if you have a claim and you're willing to only seek and ask for $30,000, this may be the place for you. But there are some problems with this legislation that are apparent already. And it'll be interesting to see how it plays out. One is that there's an opt-out right by anyone who's named a respondent in this copyright small claims court. So it's completely voluntary. There's no way to compel an infringer to stay in the small claims process. So they could completely obliterate all the good that the process would do simply by vetoing and saying, hey, I don't recognize the legitimacy of this court. I'm out. If you want to come after me in federal court. And we're just back to square one. Number two, there are no compelled injunctions in this proceeding. You can only seek damages. And then there are a number of other, when you dive into the details, there are some other problems that sort of jump off the page to someone like myself. But one thing about it is it's the first federal agency that I could detect that's ever been formed for the sole purpose of awarding money damages traditionally covered by the 7th Amendment. Now get that, it's a federal executive branch agency stepping in to do things that traditionally have happened in federal courts because they've had to happen in federal courts because of the 7th Amendment right to a jury trial. So I can get into many other details about the CASE Act, why it's a really good starting point for us to begin or reinitiate discussion, but I think we need to evolve the discussion way beyond where the Case Act is to create an effective patent small claims court. And I have many ideas, but I don't want to take too much time.
No, that's great. That's a great introduction, and we'll come back around in a bit about the event at George Washington University and where we met originally. But time to bring in Judge Susan Braden. And listen, we are so thrilled, Judge, to have you on the side of inventors, and you've spent an unusual career as a federal court judge. And maybe you could just tell us a little bit about your background there and bring people up to speed, and then your thoughts on the small claim court.
Okay, well, I grew up in Ohio and I grew up in steel towns. My father was a steel executive. So I grew up in the Middle West, and I went into the antitrust division of the Justice Department and tried the first felony case when I was about 28, and got noticed and got a chance to come to Washington and in the antitrust area in the division. And then I transferred to the Federal Trade Commission and worked for two different chairmen of the agency during the Reagan administration. And then I went into private practice, and then I went on the court in 2003, and I retired in 2018 in the spring. I was 70 years old and I decided I wanted one more act, and I wasn't sure exactly what I was going to wind up doing. But one of the things is I'm on the board of 3 different companies, private companies. 2 are involved with artificial intelligence, and the other is a large construction company here in Washington, and I'm looking for maybe one more. Let me tell you a little bit my court and how I got involved in this. The United States Court of Federal Claims is an Article I court. We're paid like federal judges, district court judges, etc., but our jurisdiction is limited to money claims against the federal government, with one exception, and that is we have injunctive authority in bid protests. Very interesting. I'll hold that thought and I'll come back to it in a second. The other thing about the court's interesting is that we travel all around the country. We go wherever the plaintiff wants us to go. If they want to come to Washington, fine. If the plaintiff is in Dubuque, Iowa, or wherever we go, we haul ourselves out there to the district court and hold proceedings there. Our cases are appealed to the federal circuit. And it's a mixed jurisdiction. About 50% of the cases are government contracts and bid protests, and primarily in the defense area. But a good 10 to 15% of the court's jurisdiction from time to time is in patents and copyright infringement. I had a little bit of background in patent law, but I had a lot in copyright, because before I joined the bench, I became famous for basically changing the law of copyright so it couldn't apply to, essentially you can't use it to protect software. And that's where everybody then went to the patent office to get patents, which they weren't prepared to issue it. And many of those are now being declared invalid because they didn't have good examiners at the time. That wasn't my fault, but I know a little something about changing the law. I know a little something about working for small companies. And my client didn't spend $1 million on me because I was stealthy and sneaky, but I beat one of the largest law firms in New York and one of the largest companies at that time, Computer Associates, in the United States, not only 4 times in the First Circuit, but also in Europe. So I have some, oh, and I forgot the Supreme Court case in Texas. So we had a lot of litigation, but you had to conserve resources, and they underestimated me the entire time. And that was good. That gave me a tremendous advantage. So I've been active in the American Inns of Court. I was president of the Giles Rich Inn. I've also been active in the American Bar Association's IP section. And Dave Kapos, when he was head of the patent office, decided that he thought it'd be a good idea to have a small patent claims court. I don't know if it was because of Bob's law review article or what was of interest to him in that. But in any event, he asked the chair of the IP section of the American Bar Association to do a study. And I was asked to be in charge of that. And the study that came out, or the paper that came out, became a comment to the USPTO about different options that could be pursued with this. The website link to that, I think, is someplace on your Bob, where did you put it?
I only emailed it to you, so we could
Oh, yeah,
definitely
post it
that.
for people because it's a good 101. It's several years old, but it goes through a lot of things. And in the back, I really even lay out procedures. And we did a lot of thinking about how to make this work. Now, I'm older now, wiser, and I've been doing a lot of thinking. What really small inventors want is not money. They want an injunction on the whole. So rather than worrying about the size of the claim, it might be useful for us to be thinking about an act that I think my old court is a good place to put this because you have a lot of people there that have patent backgrounds. They've done the cases before. They're not novices at this. And the national jurisdiction has a tremendous advantage in terms of going to where the small inventor is. So the small inventor would make a choice. They would, go to that court and seek only injunctive relief. And in exchange, they would have to just forego their ability to seek a jury trial for damages. Now, that's pretty, radical, but it's something I've been thinking about because you see, a lot of the big companies now very much want to have injunctions put back into law. You might find some support from some of those companies for something like this. And also, it seemed to me that it's useful for the small inventor who doesn't want to spend $1 million, a year litigating. They don't have $1 million a year. They should be able to get through the procedure that I had marked out within a year. I did a kind of a flow chart about how this would work and how discovery would be limited and a lot of other things. But the point basically would be to think about really what inventors really want. They're going to have to give something up, but they have to give something up that's substantial. And it seems to me that might not be a bad trade-off, but that's just my 2 cents. I have another idea, but I need to market it through Josh, which is to how to get this started. But there are a couple pieces of legislation now that I think may get out, and there may be a way of tacking on to that. We'll see.
So I think that's great that you and Josh we're meeting and we'll get together because I think you're both extremely smart and we'll figure some things out, which is cool.
Excuse me, I have to say this is not the Patents Office idea, and I'm not speaking for the group that I'm on or anything like that. That's not something that they do.
Yep.
I will say this: if we're looking for wholesale legislation, the new head of the Commerce Department had a video with the patent people in the patent office, all of them, a couple days ago, and she thinks it'll be really 4 or 5 months before they even have a director of the patent office.
Yeah.
So if that's true, if we're waiting for that, which I don't think necessarily would be something we need to wait for, but if, I think we might think about proceeding independently of the patent office completely, because from my experience talking to them, they view themselves more or less as being reactive rather than proactive.
Yeah, that's what we found. Yeah.
That's important to know. I think Dave may have been an exception.
Yeah.
For the listeners and the viewers, the background perspective on that is that the patent office is often asked by Congress for their perspective on legislation that affects patents. So they have quite a voice when they decide to use it.
Yeah, and they also have to follow the legislation which is passed in Congress. So whether or not they agree with it or don't agree with it personally or collectively, they technically have to follow the law. So sometimes we get frustrated at the USPTO because we're really frustrated with the laws. But I thought Rob, we would swing back to you, and then I want to get back to Josh again on this. Judge, we're going to come back in a bit and talk about PPAC in a second. But Rob, just talk about the conference at GW and a little bit about England and what they're doing there.
Yeah, absolutely. And I can look it up. I can't place what happened first in my mind. Either in 2012, there was a conference at GW about small claims court, and then there was an invitation in a roundtable at the patent office hosted by Director Kapos, or the other way around. It doesn't matter. But we had all kinds of professionals from all around the country, academics, heads of IP departments at the GW conference when we discussed this in a very thorough, in-depth way. My takeaway from that, what I remember best about it, was the Chief Patent Counsel of Conair Corporation was on one of the panels. And the way he explained the need for a tribunal like this is that, I think this is his exact words, it's as if Congress gives you a right to enforce a patent against infringers, but they don't, well, how do they say it? That you have a right against infringers, but you don't have a right to enforce the right against the infringers. Yeah, so that's how he said it. So basically, even for someone who's at a big company like Conair Corporation, it's frustrating. That's why I think it will be surprising to the policymakers how many large corporations could get behind an initiative like this, because large corporations have small infringement problems, if you will, just like individual inventors do. So I don't think that's something that we should take for granted. And Warren, since we're going to make this a little bit of a conversation, can I react to something from Judge Braden?
Of course, and then I want you to tell me about if you know what's happening.
Yeah, in England, and now I think I can share a slide when we get to that in just about 30 seconds. But let's do have that discussion about what do inventors want and whether a pure injunction right is all that inventors would want in this small claims channel. My experience is that this goes back to Econ 101, where you learned for the first time about comparative advantage, right? Well, that's what licensing, the whole licensing paradigm is all about. It's achieving Econ 101 comparative advantage. When there's an idea person who works in a garage, maybe is self-employed, has a great idea, gets a patent, but obviously is not a manufacturer, doesn't have a line, a plant. Meanwhile, there's a plant and a line owned by a company that doesn't have the new disruptive ideas. So Econ 101 says, get these people together and the pie expands for everybody. And that's basically what licensing is, and basically what damages in federal court are supposed to be a proxy for when negotiations have broken down. Then again, the super conservative economists would say that the injunction right is all you need to provoke that negotiation. So this could be a very interesting conversation. But let me see if I can share my screen and pull up something that will, do you see my screen? No, you don't.
No, Carmine. Oh yeah, there we go. You can see it now. There we go.
I'm just gonna pull ahead. Okay, so I can't not talk about this slide. So we haven't mentioned this yet, but there's a survey every 2 years by the American Intellectual Property Law Association, AIPLA, where they ask lawyers, how much does it cost at various levels of risk to litigate a patent infringement suit. And so when less than $1 million is at risk, the survey answers, the median is $700,000 per side. And so here's a reaction from someone in the industry. That is crazy that the expenses are so high. So let's go to the UK Intellectual Property Enterprise Court. These guys were a model for me when I wrote my paper in 2009. It was called something different at the time. It was called the Patents County Court. But they made the name a little bit fancier. It basically does the same stuff. And the key characteristic of the UK IPEC is that there's only one judge. There's one judge. Everybody knows in this case, it's his rules. And he is extremely motivated and extremely good at moving cases and basically restricting procedural rights, like discovery is extremely restricted. And you only get a 1 or maybe 2 day trial. But to get in, the entry price for getting into this court is that you have to promise that your claim for damages is under £500,000, which I guess would be what, about $800,000?
Yeah, just under $1 million. Yeah.
Right. So they also have a small claims track. So they have what I guess we would call these super small claims of £10,000 or less. And this is just something off the web where I can quote from this commentator who says, "It is difficult to present the history of the IPEC small claims track as anything but a resounding success." So, and that's generally the attitude in the UK about the IPEC as a whole. So
Rob, I have a question.
Go ahead.
Is it compelled or is it voluntary?
It is
like
compelled.
The copyright.
I believe there's some kind of removal right. But I think that's only if the claim is above £500,000. But that's a good question. Don't quote me on that because I could be very wrong about that. But my impression is it's compelled, if at least in the sense that if you're not going to litigate in front of the IPEC, you're going to, as a defendant, you still have to deal with the claim. So it's evident to me that claims brought in the IPEC stay there, whether there's a removal right or not. So here are some further details about the UK's model. The trial lasts no more than 2 days. The perception in the industry is that you get a swift resolution to the dispute. And then on the bottom in red is really the key point that would be the harbinger of success for any project like this. Active case management assists to nullify any frustrating tactics adopted by either party. So in other words, you have a tough judge who pays attention and cares about every case and moves every case forward. So that's a little bit about the IPEC. So let me
yeah, what I'd like to do, Josh, I want to ask Josh one more question. Rob, are you good? I'm going to ask Josh one more question, and then let's just open up for a free for all here, because I know you guys want to talk to each other. But so, Josh, you have so much experience, legislation, advocacy, obviously with PTAB, which we won't get too sidetracked with today. Two-part question. What's your general thought about small claims? And secondly, I'm dying to hear what you have to say about Judge Braden's idea of injunctions. So just your thoughts, and then we can open it up into a full discussion.
Yeah, I did not appreciate this history because I'm new to the scene relatively now, that this issue has been around since 2009, I think. And this is encouraging. And so there's a lot of history that understands the tensions and the challenges. And, I've got several devil's advocate questions because they get thrown at me all the time when I propose solutions for small inventors, like, what about patent trolls, right? Can people game the system? One of the big questions for me is what, if there was all this support in 2012, 2013, there seems to be broad consensus that access to justice is a problem. One, why hasn't anything been done yet? And two, why would vested interests in long, uncertain adjudications like the bar associations, the infringers, the patent trolls, why would they allow us to get away with fixing that problem?
Judge, yeah.
The trolls don't care about an injunction. That's the beauty of this, that there's nothing for them to get. So that takes that argument off.
So that leaves the lawyers and the infringers.
Hey, before we go there, Judge, could you just take a second? We have a couple people asking what exactly do you mean by injunction and injunctive relief? Could you just describe that for 30 seconds?
What an injunction is, you say to the guy that's infringing your patent, stop, don't go any further. And if they continue doing that, you go back to court for sanctions and whatever else, their firstborn male child.
So you literally shut them down.
Right.
And then wouldn't you, as a side effect from that, be able in a better position to negotiate, a settlement?
I would assume so. That's always good to be in that position. And in fact, that's I had thought originally when we got into this a couple of years ago that the thought of damages would make people want to negotiate a license, but the game has changed now, as Josh has said. There's too much money in the lawyers' fees and et cetera, to, until you're up to at least $1 million or $2 or $3 million, they don't even want to even think about it. That's chump change. So, I don't mean to be glib about this, but I just think that, you've got to really figure out a way to skin this cat. Now, you've got the Supreme Court case out there, but the on injunctive relief, which has made it difficult, to say the least, for patent owners to use it. But I think what we ought to do is take a look at the injunctive relief language that the bigger companies want to have adopted by Congress and use that model, you see. Now, if that's successful in this little context, it becomes a bit of a model for something bigger. I'm not currently a lobbyist of any sort, but I mean, I have done this in the past in my life. But my sense is that there's too many dinosaurs stomping around on the ground in this patent legislation, basically, to have anybody want to do much of anything. What we're looking at here, I think, has a lot of interesting facets. I mean, one of the things I think I'm really good at is I'm really creative. And I sent you all earlier a little paper that had been done, but this is a social justice issue as well, which has a lot of resonance right now. And I think if it's approached that way, you're going to get a little bit more attention. You're getting out of the mainstream of the dinosaurs moving around, but you have something that they might really find of interest. I have to think more about this, but I do think the social justice issue is important.
I agree with that 100%. Yeah.
And it's been overlooked. Yeah.
Absolutely. And I think injunctions, and to say that that's all inventors want, that is kind of a line out of our playbook that we've been, trying to say, what is the minimum thing that various stakeholders, invested interest will support? And I think there's a group of inventors who that is all they want. There's also a group of inventors who are happy to file their patent and let it sit, let it age for 10 years and then go sue for damages. And so, who can we help? Where are the equity? What are the equities? Who's really getting, who really warrants emergency relief? And I think there's something to that, to say the inventors who just want to stop the thief. It has an attraction in some regards, but I also think it comes with some challenges, because that is what big tech fears. They are working really hard to make sure that eBay doesn't get eased up, and that make sure
eBay is the Supreme Court case that Judge Braden just mentioned, 2006, that made it very hard to get an injunction.
So I'm afraid we could provoke a lot of resistance as well if we sit on the all we want is injunctions approach.
That's all you want.
That is what keeps some of these guys up at night, is a competitor with a better product. But it's the right narrative, and it restores the conversation about what a patent is. That's really.
Well, let me throw some ice on that a little bit. Number one, even if we're talking about small claims, probably the inventor is going to want some representation, and I think if there's no claim for damages possible, then you can't have a contingency fee, successful contingency fee structure behind the scenes. So you might be cutting off the chance for most cases to go forward at all if there's only injunctive relief, because you don't get any lawyers interested in creating a business model around these types of cases. And then another counterpoint, let's not forget, and this is in our UIA comment from 2013, which is on the PTO website. We can get Carmine the link. He can post it, hopefully, for all the comments that were published at the time. It's not a floodgates issue. Like, we have to get away from that theme that our legislation opponents or our policy opponents would be creating. This opens the floodgates by creating this opportunity for increased litigation, and litigation is always bad. That's not really true. I mean, for social justice and access to justice, some litigation is very, very good. And so I would frame this whole issue as not opening the floodgates for trolls or whoever, but rather rebalancing where there's been a horrific imbalance in the past, where we really have shut the courthouse door to entire populations of deserving patent owners and inventors who have legitimate cases against infringers, some of them willful. So it's about rebalancing, not opening the floodgates.
Bob, let me come out on the lawyer fee issue really quickly.
Sure.
In our court, and I don't remember this, but there's something called the Equal Access to Justice Act. And they do provide lawyers' fees in certain types of cases. We might want to look at that. Now they're set at a low fee, maybe, $250 an hour or something. I don't remember what it's set by statute, but how long does it take to prepare a case for injunction?
Well, if it's good infringement,
you're not doing discovery, you've got to get your act together.
If it's a streamlined case, the whole idea is it's going to be a much reduced attorney fee burden out of the gate, which is great. So if
how long can you prolong a preliminary injunction? You go into court and you scream, I want a hearing.
Right.
I need it now.
Right.
In fact, I needed it yesterday. I mean, so
right.
It's one of the problems that we have so many different interested parties that have different self-interest here. We talk about the big tech companies and all the software issues versus consumer good products, and a whole different. Everybody's looking at this differently. Is that essential to this whole argument?
That's American democracy. I mean, that's like every piece of legislation that gets enacted is a compromise of competing interests.
Well, for sure, but the ones who have the most money in this country are the tech companies, especially the premier ones. We're bigger than some small countries. So,
so on the fee shifting, it's really interesting. The idea of the American rule is it provides access to justice, but what I found is that our procedural insanity has gotten so out of control that it's flipped to where I was able to adjudicate cases in Europe and Australia where you have to pay the winner, the loser has to pay. Those were much more cost effective and streamlined. And historically, the idea is if you pay your own, anyone can access the justice system. Whereas if you have to pay the other side's fees, that means that under-resourced plaintiffs aren't able to get into court. Well, the American rule is not working. So there might be a place here. I don't want to be sacrilegious or speak completely out of turn, but I can tell you from practice, the American rule is not providing more access to justice than in other countries where the loser pays.
Well, wasn't loser pay decided in this country in 1792 when we did not follow the English system? I mean, I'm sorry, political lawyers.
You're right. And I don't know why isn't it working today is a question that should be addressed.
Well, there are something like, I don't know, 100, 200 legislated exceptions to the American rule. So it's easy from a legislation point of view to create that exception if you want to. So Josh, you're mirroring Judge Braden by saying, let's explore the possibility that we'll have fee shifting, whether it's on the model of the Equal Access to Justice Act, which, by the way, only operates against the government when you win a case against the government, I believe.
Right, but I mean, you're writing a law.
Yeah.
Okay, I mean, you write what you want in it and then see what sticks.
Right.
But I do think this fee shifting is a no-go. You got too many people that are going to come out of the woodwork against that. That's not. I would say that's not negotiable. You might as well not bother.
That's a sacred cow.
I think you have to take your chances on if you can get a access to justice issue. Depending on the size of the plaintiff that's coming into court.
Well, are you suggesting that there would be a fund for under-resourced litigants that's
there is in our court. I mean, it's an equal access to justice issue. If you're of a certain size and whatever, and you win your case, in certain cases.
Yeah, it's if an individual with a net worth of $3 million or a company with.
I don't remember forgive me, I don't remember what the number is right now, but
there is a number, but it's the taxpayers that pay when you win against the government.
That's correct.
Interesting. Hey, Judge, I don't know we'll take this in any direction that you guys want, because
I think so. What I heard, just to synthesize what I heard, I think Judge Braden's proposing that we streamline the procedures and you just have to raise the funds. I mean, it shouldn't cost millions of dollars for this proceeding. It might cost a few $100,000, but that's a lot easier lift than what we have today.
Well, you could have something where the loser pays. If, in other words, but the fees are linked to the amount in the equal access for justice, whatever level they have, you see. So it's not going to be a lot of money for the loser, or for if the defendant. Let me come back up this way. If the plaintiff wins, the defendant would have to pay the lawyer's fees in the amount that's set by that act, say it's $200.
Well, and Judge, the legislation you just wrote with your words is, I think, exactly how the UK system works. In fact, they have a reduced loser pays in the IPEC. So in their sort of big kids court, if you will, where you have giant cases, it's almost an unlimited loser pays liability. But in the IPEC, they've ratcheted that down to, I think, a limit of £50,000 or something like that. So,
Okay.
so that it's something very similar.
And you know, one concept I've heard come up in these cases is justice isn't about getting the perfect solution; it's about getting to a solution. And so, if you cap if you have unlimited expenses and these things go on for 10 years, it's diminishing returns. I mean, if you limit it to 1 year and a couple $100,000 in legal expense, everyone gets to put on their case, and you're going to get almost as good of an answer as you do in a 10-year process. And we just kind of find where that sweet spot is on getting the right answer for the optimum cost. There's clearly what we have is not optimum.
Yeah, the old saying is the perfect is the enemy of the good.
So what's underlying this, I didn't clarify, what's underlying this is a lot of the procedural protections are, there's a rationale for them, but they've gotten out of hand, where you do all these claim construction and discovery and motions in limine and expert reports and rebuttals, and they pile on all these things that supposedly have a basis in due process. But, you know, and so that's one of the reasons why the current system is so expensive and lasts so long. And so which of those how much of that is excessive, where you can still get, parties can reasonably expect to get the right outcome, a fair and just outcome, without all that excess stuff. So we want to keep, in America, we want to keep a real clear balance when it comes to due process. And we're talking about Seventh Amendment here. So that has implications. So,
well, you give that up.
Expediency at the PTAB was a total failure. So we don't want to go down a path of another expediency that throws away due process and justice. So.
You know, this is really fascinating. Judge, do you serve on PPAC, and you just started, right?
Yeah.
So you probably don't have a whole lot of experience. Are you? How does that work, and what's your advisory role? And are you involved with PTAB at all, or is that just a discussion for another day?
I'm not on the PTAB committee. I asked to be on legislation, which I'm co-chair of, and I asked to be on international, which I'm on. They have a lot of different committees, so you know, you get to choose what you want. And the way they structure it is, and everybody can listen to their meetings. They're online. I mean, they're live. You can listen to everything, and they post tremendous materials. I mean, it's just very, very impressive what's been going on at the Patent Office. The focus of the group this year is an extension of last year, which is really trying to work and help the Patent Office do what they're doing, which is to get better patents, so that when people are issued a patent, that they have a better sense of its ability to go through the hoops in the legislative process, in the judicial process. I think we may be in a period now where, like I mentioned before, people receive patents. I'm not an expert in software patents, but I think a lot of people got software patents, and there wasn't a lot of good, intelligence put in it by the patent examiners. And now that's coming home to roost. One of the things I was so impressed with the last meeting is that they have gathered, I guess, through artificial intelligence, a very robust data of all of the patents around the world now, so that the examiners will have, prior art before them that they may not have had access to before. I mean, I think that the patent office area in that area is just way ahead of its time. I must say that I was surprised, and I laughed a little bit. They were one of the few federal agencies that didn't buy this, whatever the Russians hacked.
Interesting.
Yeah, they were smart enough not to do that. And so they were up and running, one of the few people that, no one listened to them. So any of them, but I'm very impressed. I mean, I think that the office is, first of all, it's one of the best places to work in the government. That's number one. It's not political, nor should it be, and nor should it ever be. I think that the American Invents Act was a good idea. I think what's happened with the PTAB judges is, I'm not an expert, but I just understand there's kind of a cadre of older judges that are kind of doing their thing, and they're very independent of the director and a lot of other things. And so IAMCO has been trying to move people together by guidance documents. That takes a long time to do. So we have different committee meetings and subcommittee meetings, and then 4 times a year they have a regular meeting. And the day before, we listen to all the groups make their presentations. And if we have questions or things we think they should add, they do. And then the next day it goes live, and there's a transcript of the meeting, and there's a lot of materials up there, and people really ought to take advantage of what they're doing.
Well, that's awesome. And I want to put in a plug here for the AI, the artificial intelligence patent arena, because the guys at the Georgia Intellectual Property Association have really pined down on that. And we're about to beta test on the UIA website for them this program, so that inventors can go in. So over the next couple of months, we'll get that up and we'll advertise it. People can go in and take advantage of that, and they can work out some of the kinks in it.
Well, the artificial intelligence area, from what I've been able to see, is no one's depending on the patents to protect them. I mean, it's all trade secret.
In that area, but they're going to use this new technology so that you can get much more information than has ever been available before.
Right, that's correct. That's correct.
You can do your own searches now and don't necessarily have to pay for the.
Right.
So that should be something, hopefully, for inventors that might be helpful. But
one of the companies on the board have decided that they wanted to have a session about, thinking about what to do on how to plan for IP rights. And I told them there's a whole program for free at the USPTO. Just go on their website. They will walk you through all that stuff. You don't have to pay for experts to do all this type of stuff. And if you have questions, they're interested in reaching out and public outreach to do this type of thing. So they've really done a tremendous job. I mean, it's almost as good as some of the stuff on the Small Business Administration is quite good now too. It wasn't there 10 years ago.
That's awesome. Hey, Carmine, I know we're coming up towards the top of the hour. Are there a couple of questions for our guests, or we'll just keep rotating around?
We got a lot of questions in, and you guys have been answering them as we've been proceeding. So real quick, I guess a couple of people asked, and any of you guys could answer this, is what was the PTAB actually originally designed for and put into place if it just seems like it's a real problem?
Yeah, it's supposed to be fast, effective, cheap, and final.
That was the thinking about it, but one of the things that got put into it was, your patents were no longer valid. Maybe Josh, maybe you want to weigh in on that quick.
That's a good answer, but it dovetails with a lot of the themes of this conversation. Should a small claims patent court, is there a benefit to put it in the patent office, or is that a disadvantage? What are the pros and cons of that?
It's in the paper. We did discuss that. I think that there was such a backlash of feeling even then, 10 years ago, about that the PTAB was going to be overwhelmed anyway, and putting one more thing in the patent office. That would be much preferable to what they've done in the copyright area, in my judgment. But still, you know, the advantage of being in a court is that you have you can go in and try to enforce something. The more you try to make an executive agency a court, you know, it doesn't have exactly the same effect.
But Judge, I want to ask you, because one thing just jumped out at me as a layman when we went to a special PTAB event at the Patent Office a number of years ago when Josh was there, and it suddenly hit me like a over the head, like a bunch of balloons. The validity issue when you litigate something in court, you know, if you're a patent holder, have an issue patent, which you know invested in, built a business around, you at least have the premise that you have a leg up with it. But yet when you go into PTAB, you take a step back in time and your patent is no longer considered valid. That seemed like it was like written in there for other purposes. What are your thoughts on the validity issue?
My personal thoughts?
Yeah, no, well, I mean how that's affected how the outcome. It just seems like, to me, it just seems like that's a major flaw in the whole.
Yeah, I think what Warren's referring to is the downgrading of the challenger's burden of proof from clear and convincing standards to preponderance standards. That's baked into the PTAB.
It is big.
Well, it's more than that. It's just the premise is that the patents were mistakenly issued, and then effectively the burden shifts back on the inventor to prove that they did earn their patent. But I think the one.
By the way, Josh, not to go over the top of you, but the real life issue with that is you've now waited 5 years for your patent. You've now invested your life in this thing. You've now raised capital from others. So there's a lot at stake. You know, it's not just fun and games anymore.
Well, so we talked about patent quality and PPAC and all. What will really work well is for the patent office to focus on examining and issuing patents like they did for 200 years. And then let's go put this adjudication system together in some other place. And that provides incentive for them to do what they can control, which is issue patents that we can rely on.
Yeah, and my final answer is I think I agree with Josh. I think it shouldn't be in the patent office. I think it could be in the Court of Federal Claims, but I think we would need to convert them to Article 3 judges. There's some technical features behind that.
Not necessarily, because we have jurisdiction in bid protest to issue injunctions. It's in the statute.
Okay, well, offline we can talk about that, but either that or an Article 3 judge.
I've been down that road. It was not a pretty ending. The Judicial Conference was not very happy about that idea and really put the kibosh on that. So do I think they're wrong? Yes, but we made an effort to do that when I was chief, and I had a lot of Senate support in the Judiciary Committee. But the district court judges that run the Judicial Conference came down like a ton of bricks on me. So I ain't gonna work.
So how do we move forward? Because I know we're up at the top of the hour. What's the next steps to get the small claims court implemented? How do we keep this thing moving?
Yeah, you and Judge are having lunch.
We need a vehicle.
Warren will drive.
Hey, listen, this is awesome. Listen, we're there's just, we could go on for hours or days. I'm really excited that, of course, you guys individually know each other, but now you collectively do, and Josh and Judge Braden will get together. And I think that this is just the beginning. The idea is to try to coalesce around a solution that all parties can agree on, which is probably impossible, but at least the major ones have incentive to participate in. Without that, you know, it's difficult. But this has been a very, very unusual and different sort of, first of all, we have multiple guests today. Thank you all for coming on. And it's a complex subject. So this is just the beginning, not the end. And so it's a little different than most of our webinars. But if you guys, anybody wants to make a closing statement, or all three of you, we'd love to have that. So Judge, why don't you go first? What's
the question?
Well, any ending statement you'd like to make before we sign off? Yeah.
No, but I think we need to find a vehicle that's going to move. And my idea is this: you're not going to do anything legislative in a year anyway. One of the things you can do, though, is have the Federal Judicial Center is located next to Union Station, and they do terrific research and work. If the Senate does adds a sentence on any bill and asks them to study and report back to them on the parameters of a small patent claims court in the Court of Claims and how would that work, and obviously they, to different groups, you can't have everybody calling them up, but they'll assign staff to do this type of thing for Congress. That's what they're there to do. And they'll issue a report, 9 months or whatever time period you want them to have, so that at the end of, say, that year, you have something. If they say this would work, then you go into the Congress and you begin to work, because you've already gotten an imprimatur from a very important group of people. It's too difficult to have individual groups, proposing different things. It's too complicated. That's what they're there for. See what they think, if it would work. I think it would work, but they will know that, and they will be the right people to talk to the court. You can't run in and talk to the judges and say, how do you feel about this? In one sense, it's none of their business. They do what Congress tells them to do. So, because they would probably say, oh, and I'm too busy now. I'm too busy as it is. That's not what you want to do. You want to let the Judiciary Center to do this groundwork for us. And with our input, and get some sponsors to ask for that small thing. That's not a big ask. Then you have a foundation for what you're doing.
That's great. That's awesome.
That's my idea.
Well, thank you. Thank you. Rob, you want to have a closing remarks?
Yeah, and we have a window to do exactly that, what Judge Braden was talking about. We have the Case Act. That's a tailwind for us. Copyright already has small claims. Why in the world shouldn't patents have small claims? Every small business, innovative small business, and innovative individual inventor wants a way to access justice. And we need to put the patent system back into the justice system, not whatever system it currently lives.
During this time period, while the studies are going on, you see, there are going to be hearings on these other bills. So you'll be able to figure out where the lay of the land is. It doesn't have to be, it can be attached to the agriculture appropriations. It can go any place, because it's just a request by Congress. But you get a better sense of the lay of the land about what else is going to be going on, how much interest there is, maybe injunction, how much interest there is in some of these other issues in the Stronger Patents Act. And one thing I want to add in there, in the Stronger Patents Act, there is a provision for a small claims procedure, but they have asked it to go into the pilot courts, pilot patent courts.
And that's only for the benefit of small defendants, in fact.
Let me finish. But that the pilot guys are out of business. Their jurisdiction ended at the first of the year, unless somebody's going to bring that up again. So that's not a viable thing, but somebody had an interest in some type of small resolution. And we just need to do a little research and figure out who that is. But it's in that act. So there's been someone discussing it. I don't know who it was, but we'll find out.
Cool. Josh, do you want to some closing remarks?
Well, thank you for putting this together. Thank you for all the work that you guys have been doing over these past years. I'm ready to do this. It's really important. Patents are for inventors are the ones that are named in the Constitution. Inventors are the ones that are named in the Patent Act, not huge corporations. And so if we've shut inventors out of the system, then we need to get them back in again. It's so important for society. And so let's do this.
And thank you, Josh. Really, you're the face of the inventors, and have done such a great job of getting out there. And I know you represent so many, but really appreciate it. I'm going to add one more little thing over the top. Both Josh and I serve on the U.S. Intellectual Property Association board, which is a pretty large board. I'm now on the awareness committee. Josh, I don't know if I've told you this, but one of the things I've been pushing for since the beginning, and we're starting to work on it, is a national survey of some, credibility that will cost a few bucks to really find out how America and consumers feel about patents and intellectual property. You guys are all experts and involved in it up front, but does the person on Main Street really care at the end of the day? They did a recent study in Europe in 2017 that I have all the results on, and we're going to try to craft this to be really significant, because I think we need to make sure America understands what IP is and what's behind it. I think it might help the soul. I know it's a little different than what we've been talking about today, but I just wanted to let you guys know it's something that I'm going to be quite involved in. In fact, I have a meeting tomorrow and several next week on it. So hopefully we can get a consensus or a